Good afternoon, everyone. My name is Karthik Narayanan, and I am working as legal intern in LEXIS and Company. Today, I am going to answer for the question: can a property be transferred to an unborn child? So, according to Transfer of Property Act, a property can be transferred by only a living person to one or more living persons in present or in future. So that is the simple definition of transferring of property according to Transfer of Property Act. So by this definition, property can't be transferred to an unborn child. But there is an exception for this general rule. So that is mentioned under section 13 of the Transfer of Property Act, which says that property can be transferred to an unborn child, but there are some conditions or there are some certain rules which we have to follow if you want to transfer the property to an unborn child. The first thing is there is no direct transfer to an unborn child. The basic rule for transferring a property is, or the first thing that we have to consider before transferring a property is the no property shall be in abeyance at any point of time. If we want to transfer a particular property, so at that time we have to make sure that at every point of time there is some owner for the property. So if there is no owner for that particular property, that transfer is that is not valid transfer. That is contrary to the provisions of Transfer of Property Act. So there should be some owner of property. So because of this reason, there can't be a direct transfer to an unborn child. So first, for transferring a property to an unborn child, so we have to transfer to that property to a living person, and a living person for his life interest. That means he is not having the right to sell the property, but he is having the life interest in the property. He has the right to enjoy the property during his lifetime. So it is like creating a trust relationship. Our intention is to transfer the property to an unborn child, but since he is yet to born, the property since the property can't be in abeyance, we have to get the property transferred to a person who is a living being. So for that reason, first we have to transfer the property to a living person, and when the unborn person is born, so the property will go to unborn person. He is having the right over the property. For instance, if I want to transfer the property to my grandson, first I will transfer the property to my son for his life interest, and after my grandson is born, the property will go to him. So the thing is, during the date of my transfer and during the lifetime of my son, my grandson must be born. So then only this transfer can be valid, and the property will get to my grandson. So as soon as I transfer the property, even though my grandson is having the vested interest in my property, my son is having life interest. He is like a binami, or he is like not binami actually. He is like a holder of the property. He can enjoy the property for his lifetime, but the property belongs to my grandson when he is born. And also there is another condition. This is the first condition we have to follow for transferring the property to an unborn child. First we have to transfer the property to a living person, and after that the property will go to the person who is yet to born. And second thing, the property which we are transferring should have the person who is yet to born should get the absolute right in the property which we are transferring. For in the previous example, if I am transferring my property to my grandson, first I will transfer my property to my son for his life interest, and after that I will make a conditions, or I have to make condition in such a way that complete life interest in the complete interest in the property, the right to sell, the right to transfer the property to someone, every right is vested upon my grandson, because he is the one to whom he is the final owner of the property. So he should get all the rights. Absolute right in the property should be granted to the person who is yet to born, because our intention is to transfer the property to that person, so absolute right should be there. So these are the three conditions. No direct transfer to unborn child. First, the property should be transferred to one person, and from that person the property will go to another person when that person is born between the date of transfer and the lifetime of the prior interest. And the property which we are transferring we have to transfer in such a way that the person who is yet to born is having that absolute interest in the property which we are transferring. So these are the conditions which we have to follow while transferring the property to an unborn child. Transferring is legal according to Transfer of Property Act, but these are the conditions we have to follow. So So can a property be transferred to an unborn child? Yes, the property can be transferred to an unborn child subject to conditions which is mentioned under the section 13 of the Transfer Property Act. That's all. Thank you.